Hi intellectuals, welcome to our channel. In today's video, let's discuss about company law. The concept of company or corporation dates back to 4th century BC and was addressed in Arthashastra. Business structures initially operated on a small scale, often as sole proprietorship or partnership. As economic activities expanded, there was a need for more efficient ways to organize and manage large enterprises. Thus, the concept of company was evolved. Over time, it evolved to adapt to changing business needs, offering advantages like limited liability and perpetual succession. This video covers the historical development of corporate law in India and England, regulatory aspects like the Companies Act 2013 and the basic characteristics that distinguish companies from other form of businesses like partnership, LLP, etc. The word company is derived from a Latin word which was divided into two parts. The first part was cum, which means with or together, where the second word panis, which means bread. It was originally referred to an association of persons who took their meals together. A company is a corporate body or a legal person having status and personality distinct and separate from its members who constitute it. An incorporated company owes its existence either to a special act of parliament or to company law. Public corporations like Life Insurance Corporation of India, SBI, etc. have been brought into existence by special acts of parliament, whereas companies like Tata Steel Limited, Reliance Industries Limited have been formed under the company law, that is Companies Act 1956, which is being replaced by Companies Act 2013. In terms of Companies Act 2013, Section 2, Subclass 20, a company means a company incorporated under this Act or under any previous company law or Act. In common law, a company is recognized as a distinct legal entity separate from its members, capable of continuing beyond their lifetimes. Additionally, even non-profit associations can also attain corporate status under Section 8 Subclass 1 of the Companies Act through licensing. The person who contribute in it or form it or to whom it belongs are its members, and the portion of capital to which each member is entitled is called as his shares. The shares are always transferable, although the rights to transfer them may be restricted. Before entering into the important concepts of company law, let's first look into its evolution into our society. As we all know that India has drawn a lot of legislation from England. Similarly, in the case of company law, India enacted company law based upon the company law enacted in England. The three phases which influence the company law legislation may be divided as colonization era, period after World War II, the opening up of Indian markets in the year 1990. Now let's see the chronological evolution of company law in India. In 1850, first company law enactment introduced in India based on the English Companies Act 1844. In 1857, limited liability recognition in company law legislation was brought, but it was not extended to banking companies. In 1858, limited liability extended to banking companies in India. In 1866, Companies Act passed based on the English Companies Act 1862. In 1882, Companies Act recast and in use until 1913. In 1913, new Indian Companies Act enacted based on English Companies Consolidated Act 1908. In 1936, major amendments to Companies Act of 1913 based on the English Companies Act 1929. In 1956, Companies Amendment Act enacted influenced by the English Companies Act 1948. In 1952, Baba Committee was set up and its report led to the Companies Amendment Act of 1956. The Companies Act of 1913 governed Indian business companies until 1956. Now let's see how the 1956 Act is significant. The period of Second World War and the post-war years witnessed an upsurge of industrial and commercial activities on an unprecedented scale in India, and large profits were made by businessmen through incorporated companies. The Government of India took up the revision of company law immediately after the termination of last war. Two company lawyers, one from Bombay and another from Madras, were appointed to advise government on which the Indian Companies Act 1913 should be revised and recast in the light of the experience gained during the war years. On 28 October 1950, the Government of India appointed a committee of 12 members representing various interests under the chairmanship of Sri H. C. Baba to go into the entire question of the revision of Companies Act, with particular significance to the development of trade and industry of India. This committee, popularly known as Baba Committee, submitted its report in March 1952, recommending comprehensive changes in the Companies Act of 1930. The bill, which eventually emerged as the Companies Act 1956, was introduced in the Parliament on 2nd September 1953. The bill was referred to a joint committee of both Houses of Parliament in May 1954. The joint committee submitted its report in May 1955. Making some material amendments to the bill as amended by the joint committee underwent some further amendments in Parliament and was passed in November 1955. The new Companies Act 1 of 1956 came into force from 1st April 1956. Major changes brought by the Companies Act of 1956 are as follows: promotion and growth of companies, capital structure of the companies, company meetings and procedures, company accounts and its presentation, and powers and duties of the auditors of the companies, inspection and investigation of affairs of the company, the constitution of board of directors, their powers and functions, managing directors and managers, administration of company. I hope in this video we have learned what a company is and its evolution. In my next video, we will speak about key differences between Companies Act 1956 and Companies Act of 2013. Do follow our channel, The Courtroom Intellectuals, for future updates. Thank you.